Good morning to everyone who joined us today, our small event, and good afternoon for those who did it from Tokyo. Today we have a webinar, I think first of the series, devoted to structuring of cross-border supply contracts, and we will cover tax and customs aspects today. And of course, we would prefer to meet in person, not online, but unfortunately we cannot do it due to current circumstances. And but all of you will be able, of course, to ask questions so that we have a sort of discussion, which is always better than just a monologue from the speakers. My name is Georgy Daneliya. I'm a counsel and the head of Japanese desk at CMS Russia. And today the seminar will be mainly held by my colleagues, Hayk Safaryan, who is the leading partner of tax and customs team at CMS Russia, our tax guru, and also Yulia Smourova, who is a senior lawyer at our tax practice. So, and before we start, I wish to say special thanks to Okada-san of the Japan Business Club for his and his team's support with this event. We very much appreciate our cooperation with the Japan Business Club. So let's start. Today's topic is devoted to tax and customs aspects of structuring cross-border supply contracts, but we plan actually to continue this series with other aspects of the cross-border contract structuring. But most probably, for at least from our experience, for many clients, tax and customs aspects, they have special importance, especially in Russia. So the main idea of this seminar, of this series of seminars, is to deliver a message that one contract can only be a part of the system of contracts, and contracts are just legal instruments to implement your business model. So business model can be quite complex in certain cases, and even simple business model like direct sales of goods from Japan or from any other foreign country to Russia may require some preliminary structuring of these transactions from both legal and customs and tax perspective. And even a simple sale of production equipment, for example, and we will use the sample of production equipment for today's seminar, even a simple sale may sometimes require conclusion not only of one contract, but a series of contracts which work as a system and cover different aspects of cooperation between the Japanese supplier, between its local subsidiary, if it exists, and customer or dealers or distributors on the other side. So aside from pure legal and commercial issues, which are usually first thing discussed between the parties during negotiations, the structuring of cross-border transactions also triggers and requires tax structuring, PE risk, issue analysis, VAT analysis, migration rules, SRO permits, and all other aspects should be taken into consideration. And just for today discussion purposes, we prepared like 3 slides with basic 3 schemes of cross-border contracts. Of course, they are very basic, and cross-border contracts sometimes require different schemes, but those are enough, I think, for discussion purposes. So the first sample structure is a direct sale model. That is the most simple and the most straightforward model of cross-border contract structuring. Usually it applies to situations when there are just one sale, or just Japanese supplier sometimes sells its production to Russian buyers, and it's not a systematic activity. So In this case, we usually have one contract, sale purchase contract, which also, among other, covers other aspects of cooperation between the parties, which includes also installation, warranty service obligations, post-warranty service, if it exists, and also sale purchase of spare parts for the equipment sold for its lifetime or for some substantial term. The next sample structure is just a second. Yes, it's more complex. It also includes the local subsidiary of Japanese supplier as a local seller for local end customers. But the contract structure is very similar, and it includes basically same types of contracts, but first they come from Japan supplier to local subsidiary, and then second, local subsidiary resells the equipment to the local end customer. This model has certain advantages and or merits and disadvantages compared to the first one. So, and those with respect to tax aspects and customs will be discussed later today. Finally, the sample. Sorry. Yes. That's a kind of hybrid structure. It involves local subsidiary, but generally it is based on the idea to split offshore and onshore portions of the equipment supply. And in this case, some main obligations are performed by the Japanese supplier itself, and certain secondary tasks, which require usually the presence on the Russian soil, are provided by the local subsidiary. So the local subsidiary performs, for example, installation, post-warranty service, resale of spare parts, and in its turn, it is assisted by the Japanese supplier in those, because not always local subsidiary has enough qualified staff to perform those tasks. So this split offshore and offshore portion structure can be quite complex, and each arrow on this picture actually represents a separate obligation, which can mean that it can be a separate contract. So those are basically three main structures we will discuss today. And next, I give the word to my colleague, to Yulia Smourova, who will cover tax aspects of cross-border contract structuring on the basis of these samples. So Yulia, please continue.
Thank you, Georgy. Dear colleagues, thanks for joining us, joining our webinar. Let's start from the tax part of our webinar. Everybody knows that taxes always matters, especially in the modern world where the transactions and deals becomes more traceable and more transparent. And especially in cross-border transactions, taxes become crucial because you should consider and take into consideration both the Russian tax aspects in which country of the participants in the deal. During this webinar, I will first speak about the main important tax matters for each of the three discussed contractual schemes. And afterwards, I will go in more details for with respect to two specific topics, which are the hottest topics in the current tax practice and which are relevant to the cross-border supply transactions. So let's start with my first slide. It's dedicated to structure 1, direct sale modem. From the first side, it may seem that there is nothing major from the Russian tax side because we have a direct relationship between the foreign supplier, which is outside Russia, and the Russian customer who is in Russia. But in practice, as Georgy said, the supply contracts are more complex because Russian clients they insist sometimes on some guarantees. They insist on some support and maintenance from the side of the foreign supplier. So the foreign supplier had to come to Russia to provide this support, and in this respect, foreign suppliers should take Russian tax consequences for that. I will give you two illustrative examples to show how it works. The first example refers to installation and repair works. For example, we have a foreign supplier who sells the equipment to the Russian customer. This is, for example, unique equipment, and the Russian customer insists that foreign supplier does all maintenance, repair, and installation works. So the foreign supplier in this situation needs to send its own specialist to Russia to perform such works. So here we have a situation where the equipment is already in Russia, and there are foreign specialists of the foreign supplier who works in Russia. The tax aspects to consider in this case are first permanent establishment risks, because based on conditions and duration of stay of foreign specialists in Russia, Russian tax authorities may try to prove that foreign supplier makes a permanent presence in Russia, leading to PE creation. And the second important issue is VAT issue, because repair and installation of equipment which is made in Russia with respect to the equipment which is in Russia is evadable operation. So all these factors should be taken into consideration when you structure the cross-border contract, and especially when you structure the price of the contract. The second illustrative situation is that there is a Russian subsidiary of the foreign supplier which is not in the supply chain, or maybe this is a subsidiary of another foreign legal entity belonging to the same group with the foreign supplier. But foreign supplier needs some support, maybe in communications with the Russian customers, the Russian customers, with signing contracts and etc. And it asks about this support to this subsidiary. So what we see as the outcome? The outcome first is the risk of permanent establishment being recognized, because this specific Russian subsidiary may be treated as dependent agent, in this case for this foreign supplier. And the second issue which could be faced is the necessity to finance this subsidiary. I will tell you one example from my own practice. One of our clients have a subsidiary with this status. The subsidiary wasn't a distributor. It wasn't participated in the supply chain, but on the permanent basis, this subsidiary provided a support to different companies of the group in respect to different commercial contracts, which are signed by the foreign companies directly with the customers. So in order to finance such a subsidiary, the client opted to sign a service agreement where the Russian subsidiary was a service provider. And finally, after implementation of this contract, it becomes obvious that everything which is written in this contract is a great trigger for PE qualification. So you see that even if you have a direct sale model for your business, you have to consider a lot of things and to check all the processes which you are going to make in Russian commercial relationships. Let's go to the second structure. The second structure assumes that we have a Russian company which becomes a full-fledged distributor. And since this is a separate legal entity, it's assumed that formally, by law, it's a separate legal entity. But in practice, since Russian subsidiary becomes just a part of the supply chain, of course, a foreign supplier wants to control Russian subsidiary, wants to control the processes, and it may lead to some management issues in terms of this Russian subsidiary in interactions with the Russian-based employees. So as a result, the most part of tax consequences and tax risks are connected even with this situation when Russian subsidiary cannot be purely independent and there is some foreign interference. So on the slide, you will see the main issues to consider when you have when you structure your business from the second model. The first and the most important is the PE issue. In this model, unfortunately, PE still exists, and it can be materialized if Russian tax authorities are able to prove that Russian subsidiary is a dependent agent of the foreign supplier. Again, unfortunately, we had already one case in the Russian tax practice. I think you know that it's a Reflame case, when tax authorities investigated the chart of the Russian subsidiary, the way how it's managed, the way how the authorities of the Russian employees, and they came to the conclusion that Russian subsidiary is totally controlled by the foreign shareholder and acts on behalf of this shareholder. So they concluded that this subsidiary is a dependent agent of the foreign shareholder. The second issue is transfer pricing issue. It's purely technical but in any case, when Russian subsidiary have a number of contracts with its affiliated foreign entities, such contracts may be treated as control transactions, and it means that each year Russian subsidiary needs to prepare a domestic file and to prove to the Russian tax authorities that the prices in these contracts are fair. Further issue, which is also very important, is the financing issue. You know, even if the Russian subsidiary is a full-fledged distributor and it performs its own commercial operations, one day it may need financing. And when you choose the financing option, you should bear in mind not only the tax consequences of each specific option of financing, but to bear in mind how your business works in general. On the slide, I refer to some case which is quite recent. In this case, Russian tax authorities rejected the economic justification of loan financing option purely based on the business structure used. If after the seminar you would like to discuss it in more details, I will be happy to share the details of this case. And finally, within this model, for sure, besides purely supply contracts, there will be for sure a number of services contracts under which Russian subsidiary will provide services to the foreign company and provide support, and vice versa. Foreign supply could provide some support to the Russian subsidiary. So this kind of contracts should be also carefully investigated in order to define properly the VAT treatment of such contracts. And in any case, the practice shows that services contracts are always audited by the tax authorities. Let's go to the third slide, dedicated to structure 3. When in your business model, it's obvious that there is a significant Russian onshore part to be done, it's reasonable to think about splitting of contracts, meaning that it's logically that foreign supplier makes everything that may be done outside Russia and signs direct contract with the Russian customer, and Russian subsidiary also signs direct contract with the Russian customer for the onshore part. Here, the most important issue to say is that you have a very good elaborated justification file behind this scheme in order to be able to prove to the Russian tax authorities that tax efficiency and avoidance of pay risk is not the reason for this option. And the main reason for this option are purely commercial things, legal related things, and etc. As regards all relevant tax matters, I have already talked about that, because all tax matters which are relevant for this option, they are relevant for the previous options, and I talked about that for slides 1 and 2. Upon highlighting the major tax issues for each of 3 options, I will speak a little bit about, in more details, about two issues which are now developing in the Russian tax practice. The first one is permanent establishment risk. Permanent establishment risk means that foreign supplier who shows any presence in the Russian territory, either through sending its own employees to Russia or through having some relationships with the Russian partners who are acting on behalf of the foreign supplier. In such cases, foreign supplier may be deemed to have a permanent establishment in the Russian territory. Why this risk matters? This is the first and the most important issue. The first reason is that if the foreign supplier is deemed to have a permanent establishment, it automatically means that it's liable to Russian corporate income tax. If it's liable for Russian corporate income tax, it means that the foreign supplier should check also its own tax liabilities outside Russia in the country of its tax residency, maybe to elaborate some policy in order to make tax planning, distribution, and allocate profits, costs, and etc. in order to make this model effective, tax effective. The second reason is because besides and in parallel with P tax consequences, there are liabilities for the foreign companies who works in Russia to be registered with the Russian tax authorities. So it's important to understand at which moment this obligation appeared. And finally, why P is so important? If P features becomes available for the Russian tax authorities when they audit your Russian partner or Russian subsidiary, it means that you will be in the short list for the permanent control. And finally, one day maybe it will hurt maybe the reputation of the company on the global market. How to manage with the risk? Of course, it's you see that PE risk, PE concept is very complex and very difficult, and there are a lot of things to be taken into consideration. But the main algorithm here is to manage this risk on all stages of structuring of your business. On the stage of elaboration of your business, the most important issue is to understand which types of activities could potentially lead to PE qualification. Here, you should take into consideration both the Russian domestic tax law and practice, but also the applicable double tax treaty with Russia, because sometimes these treaties provide some specific terms and provisions for PE qualification. When you make contract structuring, you should continue managing PE, especially when you draft the process of negotiation of contracts, the way of signing of contracts, when you describe in the contract the distribution of authorities and risks, and finally when you define the price. And of course, the most important issue is to monitor and manage PE risks on the level of implementation of the contract, because there are maybe a lot of things which are outside, which are not on the paper, but take place in reality, and once these factors may be available to the Russian tax authorities. And finally, I can say some words about intergroup services. It's not about, again, not about the purely supply, but as me and Georgy both told, every supply contract is supplemented by a number of services agreements. And now, especially this year, when I talked with representatives of the tax authorities, they always say that intergroup services 100% are in the perimeter of tax control. Russian tax authorities are developing their approaches to control, to investigate, to audit intergroup transactions, and let's say they now have some algorithm how to check them. And even on this slide, you will see the steps. I enumerate the steps. These steps are made one by one. Usually made one by one by the Russian tax authorities within the tax audit of intergroup service agreements. The first step, it's obvious, Russian tax authorities analyzes the main set of documents. These are documents directly provided by the contract. Afterwards, Russian tax authorities request the additional documents in order to check and to check that the services is real. In this respect, they may request emails, reports, they may perform interviews with employees, they may check some information from open sources, or even send notifications, requests, international requests, which can also be the case if there is a double tax treaty between Russia and the country. A further step, tax authorities check the nature of service and compare it with the authority of the local Russian employees in order to check where there is any duplication or not. Step 4 is they switch to the pricing area. They first estimate the commercial value of service, and here the main question to answer is whether this service or really assistance which is required, or is just the way of control. Step 5, tax authorities check the correlation between volume and price of services, and very often they manage really to prove that if there is no correlation, is the reason to reject some tax benefits. And finally, when all these steps are completed, only after that they make a conclusion where the respective services are deductible or not deductible, or if the service, if the Russian company is a service provider, whether this Russian subsidiary duly declared its income from these services. So also on this slide, I refer to some recent court practices, just to show that this is really a hot topic and to be investigated. So thank you for your attention. I will give transfer words to my colleague Hayk, who will continue and talk about custom-related matters.
Just a second.
Thank you, Yulia.
Sorry to interrupt you, but for all the guests, you are very welcome and encouraged to ask your questions in the field of questions in the chat box. So please do that, and we will be happy to answer. Sorry, and please continue.
Sorry, Georgy. Thank you very much. Thank you, Yulia, for your detailed presentation, which really described the main issues that importers can face when importing and deploying activities in Russia on tax aspects. And now we will try to touch the customs aspects, which is also important when thinking about structuring the cross-border contracts. And on this perspective, we shall think about why the customs aspects are important. In fact, we have to understand that mainly customs are about firstly finance, because when importing goods we are paying customs duties and VAT to the customs authorities. And also we shall think about the limitations, which means that non-tariff limitations when we are importing goods that could apply to the importation process. And thirdly, it's about the benefits that we can on the obtain on the customs duties and VAT when importing goods to Russia, which means that we can apply some exemptions which are provided by the customs and tax law in Russia, or can be applied on the basis of a discretionary decision of the customs authorities. And in this perspective, we shall think about how to optimize custom payments. Since the customs is about the finance, then finance is a cost. We shall think about how to economize, how to optimize the process in order to get some custom privilege when importing the goods to the Russian Federation. And in this perspective, I would mention that the customs regulation in Russia is based on a Kyoto Treaty. So it's more or less similar to the regulation in the countries that signed the Kyoto Treaty. And we can say that the countries that are applying the Kyoto treaties are, in terms of regulation, has similar regulation as Russia. But in any case, there are some specifics, and we will try to mention also the specific during our presentation. But in any case, I will be short since we have not much time. in order to leave you time to ask your questions and to have a more agile discussion on the topics. And just how to optimize custom payments. Firstly, we shall identify the elements and factors that will have an impact on the finance part, on the customs duties and VAT. What are these elements? Firstly, it's the customs duties. We shall identify firstly the customs rate which will apply to the importation of the goods. Secondly is the VAT. So we shall identify which rate of VAT will apply on the goods. Then we shall identify the customs value, because the customs, the amount of the customs duties due is on the basis of is identified on the basis of the customs value. And then we shall identify the customs procedure which will apply in a specific case, because when we are talking about customs procedures, we shall think about to adapt our situation to a specific customs procedure in order to be able to opt for the privilege and advantages provided by the customs code. And then we shall think about non-tariff limitations, which means authorizations, licenses, sanctions, which will apply to specific goods, entities, or countries. So firstly, we will touch the customs duty issues, how to identify the relevant customs duties which will apply to a specific good. For that, we shall proceed with firstly with the classification of good. In Russia, as in many countries, there is a nomenclature of the foreign economic activity, which is a nomenclature of goods, and we shall try to identify to which position in the nomenclature our goods which we envisage to import to Russia correspond to. For that, one should classify the goods, which means that we shall try to have a detailed description of the goods in order to identify to which position in the nomenclature these goods relates to. When there are some difficulties to identify these goods, there are some programs that could help to classify the goods, or if there are some difficulties to apply these softwares also, then we can also apply for a classification decision, which is obtained from the state authorities, from the customs authorities. And for this perspective, we shall submit to the customs authorities an application asking to classify a specific good and get a classification to identify to which position in the nomenclature the specific goods relate to. Our recommendation for this part of steps, for these steps of the algorithm would be to avoid as it possible to make an application to the state, because the state decision is a binding decision to the company, and when you apply for a specific decision for classification, then it will be difficult to change the position of the state on these specifics, because, for example, you are thinking about a position which provides for 5% of customs duties, but then the state classify a specific good under a position which provides for 10% customs duties, then it will be difficult to challenge this decision, because the courts are reluctant to reject the decisions of the customs authority. So why our general recommendation would be to do your best to identify rightly the applicable customs position and customs rate based on your description, on your assumptions, and not to address to the state in order to get a classification decision. But the classification decision, I would say that it's a stage when you are you enter into a discussion with the customs authorities about the position of the nomenclature that should be chosen to identify the specific customs duties. Then in this case, you can think about a classification decision. Once we identify specific goods related to a specific position in the customs nomenclature, we'll be able to identify the applicable customs duties rate. Then also we shall be able to identify the applicable VAT rate, which means that we shall identify based on the customs code provision which rate apply to specific goods. The Russian customs codes provide three types of rates. The first one is the general, the common rate, which is 20%. Then there is a privileged rate of 10%, which applies to some agriculture goods, medicines, etc. And the third stage is the 0% rate, which is applied to some specific products the Russia would make favor to import to Russia because, for example, these goods are not imported or produced in Russian Federation, and the Russian state would like to make a favor to the importers in order to import these goods to Russia. Just to go to the next slide. Sorry, it does not work. That's fine now. Once we identify the applicable customs goods, we shall identify also the state of origin of the specific goods. Why it is important from financial perspective? Because the Russian regulation provide some tariff preferences for some goods which are coming from specific developing countries, and there is a list of these specific countries, developing countries, which can benefit from the tariff preferences. And for that, we shall identify where the goods are produced, processed, where the raw materials are coming from, value-added process is also important, since the customs authorities will take into account which part of added value is created in a specific country in order to identify whether the goods are coming from this specific country or not. When we have some difficulties to identify the state of goods origin, we can also submit an application to the state in order to get a decision from the state on the countries of origin. Once we identify the state of goods, we can also then identify the applicable tariff preferences. Then we should define the applicable customs value, on which basis we'll calculate the customs duties and VAT due to the state. Georgy, help me to go to the next slide, because I have some problem. That's fine. So also just to the next slide, because I will touch this slide right after. That's fine. The customs value is calculated on the basis on the following elements: is the contractual price, transportation cost, insurance cost, royalty, and commission fee. It is important to take into account that the amount of royalty paid by the importer to the supplier should be included in the customs value, because recent cases show that many international companies are just missing this requirement and have some problems with the integration of the royalties into the customs value. And in this perspective, I would mention a specific trend that we face here in Russia is that customs authorities now are trying to include dividends and intra-group service considerations into the customs value when we are talking about a situation of supply of goods by a foreign company to its 100% subsidiary in Russia. In this case, customs authorities are trying to integrate the dividends and the intra-group service remuneration into the customs value, since they consider that these payments are considered as payments with respect to the imported goods, because dividends are generated on the basis of sale of the imported goods. This position is a challenging position, but customs authorities are firmly trying to justify this position even in the courts, and now the court practice is not stable. There are some decisions which are favored to the importers, and the other ones are favoring the customs authorities. We will see how the trend is developing. Concerning the non-tariff regulation, Georgy just we passed it. I will be short on that. Since the non-tariff regulation is classical to all countries, and when you're deciding for how to organize the process of importation, we shall think about limitations, because the Russian customs regulation provides for anti-dumping measures, some sanctions, also prohibition, veterinary prohibition for importation of agricultural goods from some countries. For some specific goods, for example, for some goods which can have a dual use, there are some authorization and licenses provided for by the Russian legislation. And always we shall think about these kind of limitations. Georgy, we can switch to another slide, to the next slide. Concerning the customs price determination, there are 6 methods that applied, but our recommendation is to prepare the file in a manner to switch always and to apply always the method 1, because it is the method which provides for the transaction value method, which means that you will base your customs value always on the basis of your price contract, rather than other methods which provide for difficult formulas and difficult algorithm in order to identify the customs value. And the final stage for identification of the customs available customs benefit is specifying the available customs procedure for a specific goods. In fact, when we are planning an operation, we shall think about how to structure this operation. For example, if we are importing some spare parts which will not be used immediately and consumed immediately in Russia, then we shall think about which customs procedure apply to, because some customs procedure are providing for exemptions or for temporary exemptions of the payment of the customs duties and VAT on importation procedure. And for that perspective, we are talking about the customs warehouse procedure. Georgy, we can switch to the next, to the last slide, which is showing the available customs procedure. Customs warehouse or processing under customs control, or temporary import, which provides for temporary privilege for payment of customs duties. So is the final stage when we are structuring the customs process, then we shall think about identifying the applicable customs procedure, and it will allow us to get some benefits, financial or some privilege in terms of customs procedure. That's my last slide and point that I would touch during this presentation. And I hope we will have some questions or specific questions concerning the topics that I try to lightening during this presentation.
Thank you very much. And actually, we have a question. And it's I'm not sure whether you see it in the chat, so I will just read it. If the company has incorrectly indicated the customs value of the goods, the company has three options: pay additional customs duties to the entire delivery period, pay additional customs duties for a limited period, which one of 3 years, pay nothing before receiving a request from customs. What do you usually recommend? I think that comes to your area of competence. So could you please address?
Yeah, customs value of the good, the company has three options. In fact, I would say that it depends on which mistakes we are talking about. When we are talking about declaration of increased custom value, which means that we made a mistake, that customs value is declared more than we shall apply, then in this case we have the procedure of application for correction of the customs declaration, which means that in this case we will declare that the customs value which we declared to the customs authorities initially is incorrect one, and we will try to get the paid customs duties and VAT back to the company. It is the easiest case because in this case there is no negative consequences since we paid more to the state than we should. But in any case, we shall understand that the customs authorities will do their best to reject our application and not to refund the excessive customs duties and VAT that we paid to the customs authorities. And in this case, we'll have a discussion with the customs authorities. We'll try to challenge the position of the customs authorities in court. When we are talking about declaration of value, which is less than the customs value, we would have to declare to the customs authorities. In this case, it's another specific topic because always we have the right to submit an application to the customs authorities and to declare that we made an incorrect declaration and to pay all these customs duties to the state and try to remediate the situation. The problem here is that in some cases customs authorities are trying to open an administrative case, even a criminal case, saying that customs, the importer tried to avoid the payment of the customs duties and VAT during the importation process, And in this case, we shall structure correctly and prepare carefully our position and the approach how to correct the situation, which means that firstly we shall prepare a file identifying our mistake, identifying that we made an investigation, identifying that it's our intention to proving that it's our intention to remedy the situation. Then firstly, before paying, before submitting the corrected customs declaration, pay to the customs authorities the amount that we had to pay to the customs authorities. And after that, to submit the corrected customs declaration. And in this case, the customs authorities will not have a right to apply the fines and the sanctions provided for by the law. And also, they will not be able to try to apply a criminal liability to the responsible parties, since we will be able to prove to the customs authorities, to the state authorities, that it was a mistake that the company and the representatives of the company has corrected on their own intentions, which means that initially they didn't have an intention to avoid the payment of the customs duties. Concerning the entire development period, I would say that when we are talking about administrative liability, the prescription period is 3 years. But when we are talking about the criminal liability, the prescription period could be up to the 10 years. So why? We shall correctly define which kind of liability would apply in the case the company does not correct the situation, and the state authorities revealed these incompliance. In this case, we will be able also to identify the period that we should correct. In fact, if we are talking about only administrative responsibility, then I would say that the corrected period should be last 3 years. But when we are talking about the criminal liability, then we shall think about up to 10 years. So I think I answered to the second question. And paying nothing before we get any request from the customs, it is also a question that should be discussed firstly in order to get an answer on that. In fact, it depends on a specific situation. For example, if we face a situation that we are about expiring the prescription period, and it's a single transaction, or it's some transactions that will not repeat at the same price in the future, and we will not correct the price in the future, because if we correct the price on current importation, then the customs authorities will discover the mismatch between the price that we are applying on current importation and the prices that we applied on the previous importation, and they will start an investigation on that. If it is not the case, that it was a single or some transactions that are not regular, then we can think about this option, not to do anything and wait until we are receiving a request from the customs authorities. So as a general answer, I would say that each specific case should be investigated carefully in order, firstly, to have the liabilities that could apply to a specific company, or also to identify the applicable period that we shall correct. and then to decide we shall proceed with a immediate correction or await until we will receive a request from the customs authorities. I hope I answered to the question. If there are some clarifying questions, please ask.
Thank you, Hayk. We are running out of time, but we have another question. I think it should go to Yulia. Did your clients faced with PE investigation? So the practical question. Yulia, please.
Yes, thank you, Georgy. Yes, we had an experience in PE investigations, and from my personal experience, I had several topics when Russian subsidiaries, but when Russian tax authorities tried to prove that there are features to say that Russian subsidiaries may be deemed as dependent agents of their foreign shareholders. And secondly, I have another topic when a foreign company had a non-commercial representative office in Russia, and this rep office existed for 15 years, and all this period, tax authorities didn't raise any questions. But once this rep office was, I would say again, it was purely non-commercial, and it was never participated in commercial transactions. But when there was a decision to close this office within the tax audit, Russian tax authorities investigated in more details the activities. They requested all the employees, and finally, based on these interviewers, they collected the proof base to say that there were something related to PE, and the rep office had to pay some Russian corporate income tax. So this PE practice is rather undeveloped now, as I already said, but is developing each year. So thank you, Georgy. I think there is another question for Hayk.
Yes, another question. For what amount does criminal
concerning the criminal liability? In fact, for having the criminal liability, we have to pay attention to the two factors. The first one is the intention part of the action, which means that the customs authorities should prove that the company made a mistake intentionally, and in order not to pay the customs duties to the customs authority, to the state. And the second one is the amount. The amount provided for the criminal code, last actual reference I remember, it was 1,900,000. I have to check whether there are some changes that was introduced recently, but yeah, as I remember, it was 1,900,000 rubles, which is not a big amount, in fact. So why, when we are talking about a criminal liability, always we should take care about this level of amount of the customs duties to be paid, since it is not a big amount, and the customs authorities can try to apply the criminal liability once we are talking about on this amount of non-payment of the customs duties. But in any case, we shall think also about the intention part of the action, because when we are talking about a mistake, non-intentional mistake, we will be able always prove that we are not talking about the criminal liability, but we are talking about an administrative liability. But it will be a discussion with the customs authorities always. and we should be able to prove that based on some evidences, on some investigation results that the company would conduct in the company, within the company or specific department.
Okay, thank you very much, colleagues. Thanks everyone who participated, and sorry for taking a little bit more of your time than we should. So we will be very glad to see you on our next webinars. And thanks all of you. I think we're finished now. Goodbye.